This time we're on record in Hoagland versus Ada County. Matters before the court for oral argument on behalf of the appellant. Darwin Overson will argue. Eric Schwartz will appear on behalf of the respondent. James Dickinson will argue. Sherry Morgan will appear. Ray Chaco will also appear. Are there any preliminary matters?
No.
Very well. You may proceed, sir.
May it please the court, counsel, there are numerous important issues at stake in this case, but before launching into the specifics, I want to state what should be obvious but may have been lost in the minutia, and that is that if this court adopts the county defendant's positions, it will have effectively immunized all state actors in the state of Utah from 1983 liability in situations where the constitutional violation has resulted in death. Whether that would be a good thing or a bad thing, it certainly would be inconsistent with federal law. One of the reasons for the passage of the Civil Rights Act was to stem civil rights violations that resulted in death. And it's apparent, that is apparent from the floor debates, which we have quoted part of those in our brief. The policies behind the enactment are compensation and deterrence. And where death results, the goal of compensation is completely undermined where the personal claims die with the decedent.
Of course, the idea of compensation could have been carried out if there had been an Idaho tort claim proceeding.
That is true, but the U.S. Supreme Court has held that the 1983 remedies are independent of the available state remedies.
They're independent, but why wouldn't one also pursue a wrongful death claim?
In this, we initially did. However, the information early in the case, which is the information we included in the tort claim, ended up being quite different in nature than the claim that we ultimately ended up pursuing, and we didn't feel that the complications that might arise with the notice of tort claim was essentially worth the effort going with the state.
It was easier to try to bootstrap the wrongful death statute into a Section 1983 action?
Well, I don't think that we're trying to bootstrap the wrongful death statute into the 1983 action. I think what we're trying to do is follow 42 U.S.C. 1988, which says that if there isn't a suitable federal law, which is actually our position is that there is, that you borrow the wrongful death or survivorship law from the state statutes and incorporate it, at which point it then becomes federal law. So I don't believe we're trying to bootstrap the state claim into the federal claim as much as we are just simply pursuing a federal claim and borrowing, if you will, the state statute to determine standing as well as the nature of the cause of action. So our concern then is whether or not the policies are of compensation and deterrence are advanced fully. As I just mentioned, 42 U.S.C. 1988 requires that whatever provision is borrowed from the state court, that it serves the purpose, that it provides a suitable remedy, and it punishes the offenses against law. It also has to be for the protection, or excuse me, the purpose of the civil rights action is for the protection of all persons in the United States in their civil rights and for their vindication. So those are the dual purposes, and as I was saying, if we don't allow full recovery, the purposes of deterrence are undercut, and in fact, it would turn it on its head and create a situation where there's an actual motive to kill rather than merely maim. Because if the claims die with the decedent, liability will also be obliterated. So we're dealing with wrongful death and survivors' claims under 1983 and 1988. So can Ms. Hoagland pursue a 1983 wrongful death claim, a survivor claim, or both? And what rule applies to determine whether Bradley's personal claims survive? We start with the dispositive provision of law, and that's 1988. And the clear language of that statute states that whatever rule is ultimately adopted, it must be suitable to its purpose, and it must be consistent with federal law and the United States Constitution. That language tracks Idaho Code 73116, which is that the common law is enforced unless otherwise changed by statute. That statute requires that the laws applied in Idaho be consistent with the laws of the United States. The way to determine what rule to apply was set forth in Robertson v. Wegner and as well as this court in Evans v. Twin Falls. It's a three-step test or analysis, and the first step is whether there's a federal rule that is suitable to carry out the purpose and to carry into effect the protections of all persons in the United States in their civil rights and for their vindication. That's section 1988. Our position is that the federal law has developed since Robertson to include a federal rule of survivorship. In Carlson, which granted was a Bivens case, the Supreme Court adopted a uniform federal rule to be applied across all states where the personal claims survive the death of the decedent, where the constitutional violation has caused the death. That rule is suitable to the object at hand, and it is consistent with the policies of 1983. However, even if the federal rule did not exist, Idaho's wrongful death statute provides the applicable rule to be adopted under section 1988 to determine standing to bring a wrongful death action as an heir and personal representative of the estate. The question then becomes whether Idaho's wrongful death statute should be grafted in whole upon the section 1983 claim. And the answer is simply no, it should not, because doing so prevents recovery of damages that were personal to the decedent had he survived, such as pain and suffering. To give full effect to section 1983, it is necessary to find that those types of damages are available either under the federal rule as applied in Carlson or by finding that a common law applicable in Idaho that abates claims of personal nature is not suitable to that task. And therefore, that would take you to the third step in the Robertson analysis. And there, we basically end up with the same rule as stated under Carlson. And again, whatever rule is ultimately adopted, it becomes federal law. And as such, the directive of 88 is that that rule be suitable to the purposes of 1983. A state law that does not give that full effect is unsuitable and must be rejected. Because Idaho's abatement law does not give full effect to 1983 in cases where the victim dies, it must be rejected. It would be inconsistent with the purposes of 1983. Under the third prong of Robertson's analysis, the suitable rule would be that in cases where a litigant has standing under state law to pursue either a wrongful death or a survivor claim, the litigant may bring a 1983 action for the personal injuries suffered by the decedent as a result of the state actor's constitutional wrong. Here, I think it's clear that Ms. Hoagland has standing under the wrongful death statute. Under the rule as I've stated it, Ms. Hoagland would then be able to pursue a 1983 claim as a wrongful death claim and as a survivor claim under Section 1983. I want to talk about qualified immunity with regard to the social worker, Mr. Johnson. There are several issues under that topic, and I want to say that Mr. Johnson cannot be qualifiedly immune in this case. The trial court was correct when it found that there was sufficient evidence to present a material issue of fact on whether he had deliberate indifference towards the serious risk of suicide in this case. With that finding, however, it was inconsistent for the trial court to find that that Johnson would, that he was entitled to qualified immunity because a reasonable social worker under the same circumstances would have not known that he was violating the law. We don't need in this case, as the court knows, the elements of the qualified immunity analysis was the law developed sufficiently to put the person on notice that their conduct was violative of the law. Well, we don't even need cases that are factually similar to this one, such as Comstock, to put Johnson in this situation on notice. He has the mental state required. A factual issue exists in that regard, but he's already got the mental element of illegality. Once he has the knowledge of a serious risk of suicide, it's incumbent upon him to take some reasonable action to abate that risk. And anybody who doesn't take that action under those circumstances would know, simply based on Farmer, that they were in violation of the Constitution.
I'll accept for purposes of this question and the premise that there may have been deliberate indifference to Mr. Monroe's.
I'm sorry, I couldn't hear you.
I'll accept for the purposes of this question the premise that there may have been deliberate indifference by Mr. Johnson towards Mr. Monroe's right to receive adequate mental health care. But we've got twin claims here, and I'm having a real difficulty appreciating where there may have been a deliberate indifference to Ms. Hoagland's personal interest in a familial relationship.
Right. And I think that where we get to Ms. Hoagland's claim, in terms of her individual claim, is simply when we go through the Robertson analysis, and if we end up landing on step 2, grafting part of the wrongful death statute upon the 83 claim. The wrongful death statute, as I read it in Idaho, provides damages to an heir, which would include a parent.
But her individual claim has to be predicated upon a violation of her constitutional right. You're taking a rule of standing and trying to twist it into, it feels to me, into a...
And that goes back to the concern that I expressed at the beginning of the argument, which is that if we follow that analysis, then Ms. Hoagland can't pursue the claim as Ms. Hoagland, as an heir, for her damages in the way that we normally do in a loss of consortium.
And that's due to her failure to file a timely tort claim, essentially.
Well, whatever...
Well, we don't know why, but we know that she voluntarily abandoned the state wrongful death claim.
Right. So if that claim can't be brought and pursued, then that leaves us in a situation where there has to be some avenue to pursue a claim for the personal injuries or personal cause of action of Bradley Monroe. Otherwise, there's no compensation and there's no deterrence for constitutional violations in cases where death results from the violation. And as I said, that result would effectively immunize every state actor in the state of Idaho from 1983 liability in situations where death results.
But the reason I'm trying to tease that out is that given we can never compensate Mr. Monroe for any violation of his constitutional rights,
Correct.
and that's why I'm struggling to find a constitutional right that Mr. Johnson exhibited deliberate indifference towards that belonged to Ms. Hoagland?
Well, as with the loss of consortium claims under state law, the 1983 action would be derivative. It would be a derivative action in the sense that the relevant constitutional right that was violated would have been Bradley's. Now, we obviously have the Trujillo case out of the 10th Circuit, and we also have, like the 9th Circuit that just simply recognizes a due process interest in that relationship. If the court decides to follow that line of reasoning, it's a pretty easy question to answer. I think if you follow...
Is there any line that can ever be drawn then as to constitutionalization of state law claims?
Well, I
if
think...
we adopt that approach?
Yeah, I think, and that takes me back to the wrongful death statute. I think that's the purpose of looking to state law, is to fill that crevice, to draw that line as to what relationships would be protected. Under that statute, a parent, a spouse, a child, those are recognized familial interests.
So the state statute defines the scope of the constitutional right?
To some extent, yes.
So if Washington has a wrongful death statute that affords it to nephews and nieces and grandparents, would you have a different set of constitutional rights in the state of Washington under the federal Constitution than in the state of Idaho?
You know, I would have to say yes under that analysis, yes. And whether that, rings rational or reasonable, I don't know. But one of the things is 1983 protecting individuals not only just from the constitutional violations of the various amendments, but also equal protection under the state laws. And frankly, that's taking the
analysis. It seems to run completely afoul of the notion of equal protection if nieces and nephews in Idaho aren't protected, but they are in a different state.
I agree, and that's why my position is that we end at step one, and we have a uniform federal law of survivorship here, so that we don't run afoul or run into these logical inconsistencies where, if the state of Louisiana wants to include the great uncle of the aunt, then somehow we...
So Congress essentially can define the scope of a constitutional right.
Well, Congress has to some extent, in the sense under 1988, they have left it to the courts to develop common law and directed the courts to look to state common law and state remedies as a means of filling in the necessary rules to effectuate 1983.
But haven't they really prescribed a remedy for violation of constitutional rights rather than defining the parameters of constitutional rights? I mean, the predicate for recovery is a violation of constitutional rights.
Right. I think, correct me if I'm wrong, but I think what you're driving at is that we have to first find a violation of the Constitution before we even delve into 1983, what remedies would be available, what rules to apply, and then we're down to 88, and that's absolutely true. And I think here, the clearest violation of a constitutional right is the violation of Bradley's constitutional right to reasonable health care and safety within the institution. I hope I've phrased that correctly.
Yeah, although my questioning originally was focused on Ms. Hoagland's individual claims, not her claims as the PR.
Right. And I agree with Your Honor in the sense that they are problematic and that they have created some confusion even within the federal circuits. The U.S. Supreme Court has not taken this case or this issue on head on. So we don't have a complete answer.
Just as a matter of history, I know that you're relying on the Ninth Circuit. Historically, when there's been a significant split, the Ninth Circuit's on the short end of the deal.
Well, that's
how likely are they going to do?
Yeah, that is true. It is a busy circuit, though, and they do see a lot of these cases. So we don't know. One thing I want to make clear, when we do look at this, as I understand it, Johnson's argument is that he didn't have clear notice because he didn't know that he might be hauled into state court and sued by the mother. I just want to point out that what is relevant is the constitutional, that he knew he was violating or he had deliberate indifference to the serious risk faced by Monroe, and failure to act violates Monroe's constitutional rights. He should have known that. He had fair, abundant notice that a failure to act would violate those rights. What doesn't matter is if he was on notice of who would sue him, what type of action would be brought against him, or where that action would be filed. None of that is relevant to the analysis. The only thing that's relevant to the analysis is knowing what he knew. Did he know, was he on fair notice that failure to act would violate Bradley's constitutional rights? Because the test is quite simple, and it's under similar circumstances as those faced by the officer, and given the then state of the law, would a reasonable officer know that his or her actions or inactions would result in a constitutional violation? It's a simple rule, and in this case, the answer is clearly yes. A reasonable social worker with that state of mind would know. Once the social worker has that state of mind, the social worker can avoid liability still by taking reasonable steps to avoid or to abate the risk. Now, that doesn't make him a guarantor of the inmate's life. If he takes reasonable steps to abate that risk and the inmate still commits suicide, no liability. If he fails to take any steps to abate that risk, then that social worker is going to be held liable under 1983. I think this case falls clearly within that latter category. So let's talk about what is deliberate indifference in this context. It's where an officer subjectively knows that a prisoner faces a serious risk of harm, and with that knowledge in hand fails to take any reasonable action to abate the risk. It does not require intent. There's been some...
I'm having a little difficulty with that proposition. The standard is not indifference, it's deliberate indifference.
That's correct.
And deliberate has a well-defined meaning, signifying carefully weighed or considered, studied, intentional. Something not happening by chance.
Deliberate indifference has been traditionally a term of art in the law, and I think a good case to look at is Smith v. Wade from the United States Supreme Court, and they've repeatedly defined deliberate indifference in this way. At times, some courts have interjected the language of intent, and that's a mistake. None of the U.S. Supreme Court cases do that. It's akin, according to the U.S. Supreme Court, it's akin to recklessness as a state of mind. All it requires is that the individual be aware that that person faces a risk of harm, whether it's suicide or danger from other inmates, or they need their diabetic medication. If they're aware and they do not take action, they're liable. That's how you meet the test. It does not have an intent element to it. It's the same level of, to borrow a term from criminal law, mens rea, as what's required for recklessness in the criminal context. It doesn't necessarily mean that you intend the outcome. Intent really has no part in it. Although, if you intentionally harm somebody or you do act with intent, you certainly meet the deliberate indifference standard. here in Idaho, it's also the standard for obtaining punitive damages, and the same would be true at the federal level under Smith v. Wade. So we believe that that mental element, it's not a matter of belief, it is the case that that mental element, while it is generally recognized that it's a difficult element to meet, it can be met by circumstantial evidence. Simply because the officer involved, and by that I mean state official, says in testimony that he didn't know, doesn't mean that there's not a material issue of fact on that issue if there's other evidence to suggest that he did know. And I think the trial court was correct when it found a material issue of fact on that issue. It was on the second step that I believe the trial court erred. But also in this case, with regard to Deputy Wroblowski, the trial court missed a step and found that despite Wroblowski subjectively knowing that Bradley faced a serious risk of self-harm, Wroblowski did not act unreasonably. I believe that's the language from the trial court's order. I think that was reversible error in the sense that the trial court clearly misunderstood the timeline involved. Wroblowski, the court believed, and it's pretty apparent from the memorandum decision, that the trial court believed the social worker was present at the time that Wroblowski interviewed and asked the suicide questions. He was not. That suicide interview by Deputy Wroblowski didn't take place for another 20 to 30 minutes later after Johnson had left the area. The court also misconstrued Deputy Wroblowski's understanding of policy and his experience as a law enforcement officer. He had graduated from post, if I recall right from the record, twice. Once when he was a guard out at the Idaho State Prison, where he had to deal with these situations. So he had that experience under his belt. But more importantly, in his deposition, he expressly stated that he understood the policy that if any of those suicide questions were marked affirmatively, that it was incumbent upon the officer at that point to contact the medical unit. He didn't do that, and he didn't do anything. The trial court felt that he had his supervisor available to him, but somehow that took the advantage of him to take some action. Well, I would say that the reasonable thing to do, if you're going to look at his supervisor, is contact the supervisor and say, what should I do? But instead, Wroblowski simply does nothing. His testimony comes up that later, after the fact, that somehow what he meant to say was that Bradley was suicidal the night before, but not now. That does not appear in the record. The record is in the present tense. He had made notes in the record that he created elsewhere, but yet he didn't make them in that part of the evaluation record. Well, that is very similar to the situation in Woodward, where the nurse did the very same thing. She marked, yes, the individual appears to be at risk for suicide, but used the present tense and didn't include any type of note to qualify that what she meant was the individual had been suicidal but wasn't now. I want to just briefly touch on the punitive damages and indemnification argument that's been raised by the county. Punitive damages are available in this case simply because the mental state required is a deliberate indifference standard. The Supreme Court's been really clear that Smith v. Wade, that intent is not required to obtain punitive damages in these cases. And as Judge Lodge recently ruled, It really doesn't matter that the counties chose to indemnify its officials for these types of damages. That's the county's choice. It really has no impact on the federal law, and this is federal law that's being applied here, even though we're in state court. And the federal law clearly permits punitive damages to be awarded in these types of cases. So if the plaintiff is entitled to seek punitive damages under federal law, then the state simply can't frustrate that by indemnifying the individual officers without running afoul of the supremacy clause.
Sir, at this time, your time is up.
Okay.
Thank you.
I was actually just going to say that because I was looking at the clock here. Thank you, Your Honor.
Chief Justice Burdick, Justice Jones, Justice Eisman, Justice Jones, Justice Horton. May it please the court, my name is Jim Dickinson. I work for the Ada County Prosecuting Attorney's Office, and I represent Ada County Deputy Jeremy Wroblewski, social worker James Johnson, the Health Unit Services Administrator Kate Pape, as well as the county and the Monell claim here. I'd like to just go through very quickly the issues in this matter. First, the plaintiffs can't bring a lawsuit under 1983. The difficulty begins with who the plaintiffs are here, but neither the estate nor Ms. Hoagland can successfully sue in state court under this 1983 theory. Next, another problem with the case, another impediment is the defendants are protected by qualified immunity. All of the defendants in this matter save the county, but the individual defendants are protected by qualified immunity. The district court didn't do that analysis. They did just a deliberate indifferent analysis, but they did do the analysis for Jim Johnson. And so that qualified immunity is the next roadblock to this case being a successful case. Next, plaintiffs can't show the defendants were deliberately indifferent. Of course, that's part of the qualified immunity standard, but it also is a standard by which both Deputy Wroblewski and Kate Pape were dismissed from the lawsuits. They were not deliberately indifferent. Plaintiffs cannot prove a Monell claim here. Monell is the case that allows counties, cities to be sued. In this particular instance, there's not a Monell case here. There are no particular specific express policies enacted by the commissioners or the sheriff that constitutionally led to the suicide. And for that reason, the Monell case, no Monell claim can stand. Now, we'd like to expand on the arguments we just enumerated. Keeping in mind, case law talks about 20/20 hindsight in these matters. It's so easy, and it's so human, and it's so natural when one sees an outcome such as this to look back and start looking at all the things along the way where things could have been changed. But the courts warn 20/20 hindsight is not a fair way to view these cases in light of the fact that the defendants didn't have that. The plaintiffs can't sue under 1983 as neither the estate nor Ms. Hoagland can bring that claim. First, the estate can't sue, and that's a survivorship. That's based on survivorship. That's Idaho Code Section 5-327. When the action that's sued for is what resulted in the death, it doesn't survive. It's common law, and in 2010, the Idaho legislature readopted the common law by specifically putting that in the statute. This case, in Evans, has indicated that that is the law in Idaho. And the federal court, the Idaho District Federal Court, followed that in Anderson. And then most recently, in Bach, the Idaho federal district court followed in Bach, that actually cited to Evans and said in Idaho, survivorship of an estate, in that case it was actually somebody suing on behalf of a decedent, but the cause of action passes with the decedent. The lawsuit brought by Hoagland that Justice Horton was inquiring about earlier was brought, and the district court allowed standing based on Idaho's wrongful death statute. And the questions from the court from both Justice Jones were, doesn't Idaho provide a remedy in these instances? And yes, it does. And Justice Jones is correct. It's Idaho, it's a wrongful death statute. It's Idaho Code Section 5-311. In this particular instance, though, it was brought and pled, as the court has already alluded to. The court used the word bootstrap. Idaho Code Section 5-311 was used for standing, and the court only recognized that. The district court recognized that it was just the standing portion. And the problem with even if you allow that standing, even if you allow Hoagland's lawsuit to get in the door, the problem is the constitutional right after that. There was a constitutional right, at least in the Seventh Circuit. There was a finding in 1984 with Bell versus Milwaukee that a parent could sue for the death of an adult child. And Bell allowed that in the Seventh Circuit in 1984. But over those 30 years, over the next 30 years, as the Seventh Circuit allowed those types of cases, they realized no other circuit was recognizing it, save for the Ninth. And in 2005, the Seventh Circuit said, parents can't sue for the death of an adult child any longer. There's no constitutionally actionable right. So we're in a position now where even if Hoagland's allowed standing under 5-311, there's no constitutional cause of action for 1983. The law of the First Circuit, Third Circuit, Fourth Circuit, Sixth, 10th, 11th, and the District of Columbia circuits all say there's no cause of action for the death of an adult child. The next portion of, at least the next defense, and the reason that that the court dismissed the case against Jim Johnson at the district level, was qualified immunity. Qualified immunity has been visited very recently by this case in the Miller versus the Idaho State Police. I think it's captioned differently, but the Idaho State Police case, where this court did an analysis that we've actually followed in our briefing for qualified immunity purposes. And that is, there are two steps to qualified immunity. There's a clearly established, and there's the deliberate indifference that the court's already talked about, the deliberate indifference standard within qualified immunity. Saucier and Pearson, two U.S. Supreme Court cases, are very clear in how qualified immunity works. Saucier sets it out very well, but Pearson allows the courts to take either, to talk about clearly established law first now, because Saucier had a rigid marching order and how you had to analyze it. This court in Miller adopted that position and says, and the court says, whichever way is easier for qualified immunity, whichever way is better for the court can take them in either order. In this particular instance, we suggest that the court first look to see if the law was clearly established in this instance. If the law is clearly established, then you move to the next portion of qualified immunity. And that next part of qualified immunity is whether the actor acted with deliberate indifference. But that part of qualified immunity means the court has to go through a merits analysis. And that can be a very difficult portion of qualified immunity analysis. And if you don't have to get to it, why should you? And that's what the Supreme Court said, and that's what this court's adopted in Miller. In this particular...
Excuse me, Mr. Dickinson. On this question of qualified immunity, the appellant certainly is directing our attention to what appears to be a misstatement in Nation, where the word immunity is substituted for the word injury in terms of how the court, considering a claim of qualified immunity, is to view the evidence, that is, to take it in light most favorable. And would you agree that the statement, at least in Nation, appeared to flip the Saucier standard on its head?
I would agree. Should I argue a little more?
What's that?
I said maybe I should argue a little more, but I think the nation, I think it's a typo. I think it's flipped.
It should have been injury rather than immunity.
Well, I don't know about injury and immunity. The one I'm thinking of is where it talks about the law being looked at most favorably to the defense. I'm sorry, I don't...
Well, the statement in Nation is that the qualified immunity analysis is taken in the light most favorable to the party asserting immunity. Saussure talks about it, taken in the light most favorable to the party asserting injury.
Oh, exactly, okay. Yes, we're on the same, yes. I
Well,
agree.
it is significant in context of a
I'm
summary
sorry, yes,
judgment
I'm sorry, I didn't see it in
Yeah.
that way. Exactly. And in this instance, actually, the district court did. If you read, I mean, I'm sure the court has read, if you read the district court's analysis, in the stated summary judgment and in the reconsideration, every time the court made a finding, the district court talks about viewing the facts in the light most favorable to the plaintiff. And so it didn't affect what this court, or excuse me, what the district court did in this particular instance. Part of the theory of looking to see whether, I'm sorry, back on qualified immunity. I guess we were still. Qualified immunity is for the court to make a determination of whether that law is clearly established because of constitutional avoidance. There's just no reason to go through that deliberate indifference analysis if you don't need to. And it's our position, at least we're asserting today, that the law was not clearly established in this particular instance for Johnson. Johnson had 20 years, Jim Johnson was a social worker with 20 years experience, and the jail did all of the right things. They called in a social worker, asked the right questions, had a social worker did an assessment, and all of those things are the things that the courts expect to see a jail doing. And because they did all the right things, there's no clearly established law. The law can't drill down that deeply and tell and explain to a jail exactly what it needs to do beyond that. That is, have a mental health professional come in and talk to this young man, and that's what they did. As far as the second part of qualified immunity, that is a violation of a constitutional right, the first part was clearly established, and we submit that the law wasn't clearly established here. And secondly, the violation of a constitutional right has two components. One is subjective. Earlier, Hoagland asserted that the deliberate indifference didn't have that knowledge standpoint. That particular case, the case that was cited to in that instance, Smith v. Wade is a punitive damages case. It's not a qualified, at least for that purpose, the deliberate indifference was a punitive damage portion of that. However, if you look at Saussure, you look at Pearson, you look at this court's Miller, the subjective element is that Johnson had to know, he had to be subjectively aware that Monroe would likely commit suicide, and that he had to intentionally disregard that risk. It's our submission, as the court found, that was not the case. He was not subjectively aware that Monroe would likely commit suicide. And because he was not, he could not have intentionally disregarded that risk. Both Wroblewski, Deputy Wroblewski, and moving now to the deliberate indifference portion of the analysis by the district court in dismissing Wroblewski and Kate Pape, the court analyzed it according to, applying the deliberate indifference standard. And that is that Deputy Wroblewski, who interacted with Monroe and asked the questions, it's the same standard we just talked about. Wroblewski would have had to have known that Monroe was likely to commit suicide, and then he would have had to intentionally disregard that risk. And the court found that it was not the case, that Wroblewski acted in a reasonable manner in what he did. Kate Pape is head of the Health Services Unit at the Ada County Jail. She is also a social worker. And The lawsuit against Kate Pape, moving to that part of the deliberate indifference argument, and the lawsuit against Kate Pape is a different lawsuit in that there's no respondeat superior for just because Kate was the head of the medical services unit. Further, because of her position, she had no interaction with Monroe. So as an individual actor, she can't be sued in that capacity. So they need to show, and Hoagland can't show and has failed to show, that she knew of or condoned or acquiesced in some kind of unconstitutional treatment of Monroe or in the jail as a whole. And there's no specific policy, which they have to show. There's no specific custom, and there's no unconstitutional practice that was going on in the health services unit in the jail to lead to any kind of a finding, and that's why the court dismissed Kate Pape as well. Monell is the basis for any claim, and moving to Monell now. Monell claims are against counties or cities. In this particular instance, a Monell claim against the jail can't survive and didn't survive and was dismissed by the district court, just like the case against Kate Pape. That is, there was no evidence that the Board of County Commissioners, Ada County Commissioners, or the jail had any unconstitutional policy applied, any unconstitutional custom, any unconstitutional practice, none of the above, that led directly to the suicide. I'd like to move now and discuss costs. Costs were properly awarded, we believe, by the court. The court went through and did an analysis on costs as a matter of right, went through and actually didn't allow all of the costs that the county had asked for, and on discretionary costs, did the same, went through and made the finding, just as the law requires, and determined that the majority of the costs that the county had set forth were appropriate costs in defending this action. The county cross-appealed on a few issues. I won't spend a lot of time on them. The first was discovery protection. In 1983 law, the Supreme Court and the courts of appeal provide or allow to be provided protection from discovery. That discovery is because immunity, or qualified immunity in this instance, qualified immunity isn't just a defense, but it's immunity from being sued and all those things that are contemporary with being sued. And one of those things is dealing with discovery. I want to point out to the court that we didn't move, that the county didn't move for protection until the county had already answered 50 interrogatories without objecting to the fact it was over the limit, without answering 45 requests for production, 170 requests for admission, 11 supplemental answers, and over 4,000 documents. We did that for a couple of reasons. We provided that because it was our hope that once the plaintiff saw what really happened at the county, that the case would be dismissed. And for another reason, we think in fairness, the plaintiffs needed to know something about the case before we could go further. And so before we asked for protection, before we asked for protection, we at least complied with the bulk of discovery. And what we asked this court for is some direction to district courts, at least in the state of Idaho, as to discovery protection. The punitive damage portion of the argument we make is that the United States Supreme Court said in Newport versus Fat Concerts that when punitive damages are sought, and in that case it was against the city, not individual actors, when punitive damages are sought, the government is immune because if there is an award of punitive damages, the taxpayers are the ones who are going to pay it, not the person who actually was found to have acted in a way to, for the jury to have awarded punitive damages. And because of that, we submit it's the same in Idaho because statutorily, counties in Idaho must defend and indemnify employees who act within the course and scope. It's our position that it's the same as Newport Fact, that is, a punitive damage award against an individual actor in Idaho means that we will, that the county and the taxpayers will end up paying. I did make a mistake actually in the briefing, and I apologize to the court, and I want to call it to the court's attention. I stated that the plaintiffs sought punitive damages, still on this punitive damages argument, but they sought punitive damages against the official and individual defendants, and they did not seek them against the official capacity defendants or the government. They only sought them against the individual. We asked the court as well for attorney's fees. The district court disallowed attorney's fees. It was our position in this particular case that based on the totality of the case and the case being brought without reasonable basis, we believe they should have been awarded. And lastly, the motions to strike, we set those out and argued motions to strike on particular matters of evidence. Hopefully the case will not be remanded, and if it is not remanded, then those matters will be moot. I suspect the court doesn't want to take up a lot of time that we brief the motions to strike, and I won't go into those at this point in time in any detail. I'm sorry. Excuse just for a second. Are there any questions from the court?
Appear to be none. Thank you.
Thank you, Chief Justice.
How much time does the appellant have? At this point in time, this matter is submitted under advisement, and we will render decision. Thank you.